I'm hopeful that this committee will add language to this bill to support small businesses and ensure a timely chain of payment between owners, contractors, and subcontractors on construction projects in this state. I've submitted lengthy written testimony that I would ask you if you could please look with a lot more detail. And specifically, my suggestion is that Section 42-158J of the Connecticut General Statutes be amended to model the terms of a portion of the Virginia's law. And again, I've submitted all that with my testimony. And I would like to yield my time to one of my constituents who brought this to my attention, Carmen Barker, and also Michelle Lemoy.
Thank you, Representative Vail, for yielding your time. Good afternoon, Legislative Committee. My name is Carmen Barker, and besides me is Michelle Lemoy, the Senior Project Manager and also the Senior Business Development Manager for Division 5 LLC. And I would also like to acknowledge the owner of the company, Conrad Barker, is also sitting out there. Just continue?
Yes.
Okay, alrighty. We are here on behalf of Division 5 LLC. We are a small minority-owned business. We have been in business for going on 11 years in April. We have about 16 employees combined of full-time and part-time employees. We fabricate and install miscellaneous and structural steel, and the majority of our work comes from commercial properties. So basically, if we win a bid on a project, the next step is to get the contract signed from both parties, from the owner and the general contractor. And the contract will detail the cost of the project and other pertinent information. We are here today because, one, some owners/general contractors fail to pay in a timely manner, which causes us to lose our lien rights. As per Connecticut Lien Statute 49-35, a notice of intent to lien in Connecticut must be sent no later than 90 days after your last day of work. And this happens quite too often. We are promised either we would be paid or there's been a delay in payment, which leaves us with the burden of being unable to pay our vendors, not being able to pay our vendors on time, or looking for other ways to fund paying our vendors. This is a trickle-down effect for everyone involved. If we don't pay our vendors on time, then we're not able to place an order to start another project. So this is why it is important for our owners and general contractors to pay us in a timely manner. The second issue we face is how the contracts are written. They will say paid when paid or paid if paid. So where does this leave us? This has caused us many headaches. General contractors have been known to be untruthful and say we have not been paid, and this leaves us, completing work, satisfactory work, and not receiving any payment from them. Sometimes the general contractor's already moved on to another project, so now we have to take on the burden of hiring an attorney to find out if they were paid. And there have been times when the owners have said, yes, I did pay them, so now that's another burden for us to try to either bring them to small claims court. The verbiage in this contract does go against the Connecticut Lien Statute, and it should not be enforceable. Connecticut's small business are not the only ones facing this issue. In April of 2022, the Virginia General Assembly passed Senate Bill 550, which makes paid when paid or paid if paid clauses unenforceable, and in most circumstances requires both public and private construction contracts to include specific payment clauses that obligates the contractors to be liable for the entire amount owed to any subcontract with which it contracts. I am asking that owners/general contractors who fail to make timely payments should result in interest penalties. Payment should be made within 60 days of satisfactory completion of the subcontractor portion of the work, and remove verbiage from contracts that say paid if paid or paid when paid. And any construction contract that runs counter to these requirements should be voided and unenforceable.